Good morning to all. Today, we will discuss one case law from the IBC, which is relating to also relates to the somewhere relating to Companies Act sections also, where a compromise agreement, that is, an compromise scheme is submitted under Section 230 of the Companies Act with respect to a company which is under liquidation. This scheme was submitted by a shareholder of the company. So he submitted his scheme, but what happened? This scheme was not present before the presented to the COC in presence of that shareholder. So he filed an application before the NCLT, and the application is dismissed. And he filed an appeal before the NCLAT, and NCLAT has held that the scheme should be presented to the stakeholders consultation committee in presence of the person who has submitted that scheme, that is a shareholder. In absence of this presence, in this absence, it is submitted, it is not valid. So this was the court has said. Let us see what the case is. Honorable NCLAT Chennai has passed this order in the matter of Sanjeev Mitla versus Madhusudan Rao Gonukunta and others. And another case number is given. Order is delivered on 29th of November 2023. The observation given in this matter is scheme of compromise decided in absence of shareholder who submitted it. NCLAT Chennai directs reconsideration in presence of the shareholder. So case is that the Surya Jyoti Spinning Mills Limited was admitted to corporate insolvency resolution process by the NCLT. Subsequently, the NCLAT ordered liquidation of the corporate debtor. Sanjeev Mitla, appellant, is a shareholder of the corporate debtor. The appellant submitted a compromise scheme under Section 230 of the Companies Act to the liquidator for restructuring of corporate debtor's debt. The scheme offered payment of 90 crore rupees to the finance secretary as against an outstanding debt of rupees 469 crores besides payment of liquidation cost. The stakeholders consultation committee has decided to conduct e-auction of the corporate debtors asset, and reserve price was fixed at rupees 155 crores. The appellant placed the appellant scheme, the liquidator placed the appellant scheme before the stakeholders consultation committee, but in absence of the appellant. The stakeholders consultation committee rejected the scheme by 97% vote, while holding that selling the assets in e-auction would fetch higher value. The liquidator conveyed the decision of stakeholders consultation committee to the appellant and also published the e-auction notice. In the meanwhile, the appellant filed an application before the NCLT seeking that a meeting of SEC be convened to consider the scheme. The NCLT dismissed the application on 8/9/2023. Thereafter, the appellant filed an appeal before the NCLAT. The appellant contended that the liquidator violated Section 230, subsection 1 of the Companies Act 2013 by not presenting the scheme before the SEC in his presence. Therefore, the appellant could not persuade the SEC in respect of the scheme submitted. So he is not given an opportunity to explain the scheme and its features and advantages and benefits for the company. He is not able to explain to the SEC. That's why he has agreed by the act of the liquidator and filed an appeal before the, that is made an application before the NCLT and also the appeal before the NCLAT. This is the cause of action. The liquidator admitted that the scheme was placed before the SEC in absence of the liquidator appellant. What the NCLAT held, that is, the bench took the view that in interest of justice, the scheme should be placed before the SEC in presence of appellant. In view thereof, we are of the considered opinion that it would be just an expedient if the proposed scheme propounded by the appellant is put before the SEC in his presence, on which SEC may take a decision. During the course of hearing, the liquidator submitted that the proposed scheme will be put to the SEC on a fixed date, and appellant agreed to the scheme. Did the same. As a result, what happened is the order was passed. While disposing of this appeal, the court directed that, as per the agreement between the parties, the scheme propounded by the appellant in terms of Section 230 of the Act shall be presented before the SEC on 1/12/2023. The meeting shall be convened by the liquidator on 1/12/2023 by giving time, date, place of the parties concerned, and in that meeting, the scheme shall be considered by the SEC as a decision will be taken in accordance with the law. Accordingly, the appeal has been disposed of. So what it means is a scheme which is given by a promoter or shareholder, in case of liquidation, a compromise scheme, it should be presented in his presence to the SEC. Otherwise, the scheme is not, otherwise the action is not a valid action. Okay, so any doubt on this, you can ask to me now. Anybody?
No, sir.
Okay. Next session.
So I will be taking the next session.
Okay.
Good morning, everyone. Can you hear me?
Yes, Khushi.
So today we will be talking about how we convert a loan into equity shares as per section 62(3). First, we have to make sure that the company and the other company has in the contract that they can convert the loan into equity shares in the near future. So during that time, they also have to pass a special resolution which specifies the loan may be converted into equity shares in the future. For this, we will also have to file MGT 14 within 30 days of passing the special resolution. Then we have to check that the company has sufficient profits so that they can convert the loan into equity shares. Third, we will have to obtain a valuation report. We have to only obtain a valuation report if it is not predetermined the value of the equity shares, which the face value of the shares which we will be giving the company to. The fourth step is to pass a board resolution approving the conversion of loan into equity shares. This resolution shall specify the terms and conditions in which the loan shall be converted into equity, the number of shares that are being issued in exchange of the loan, and the price per share. This price is also determined in the valuation report. Now, step 5 is to pass a special resolution. We will be calling an EGM and pass a special resolution for the conversion of this loan into equity. Then we will file MGT 14 within 30 days. And over here, we will attach a notice of the EGM with the explanatory statement and a copy of certification of resolution passed during the EGM. Once all of this is done, the last step is to file E-Form Pass 3, which is for allotment of shares. And over here, we will attach the list of allottees, which will be the lender, a copy of the board resolution, which was passed in the board meeting, and the special resolution, which was passed in the EGM. We'll also attach the valuation report. In case we are issuing these securities, if in kind or something, then we have to also issue a copy of contract. And if we are issuing bonus shares, then we have to give a copy of the special resolution during the issue. Thank you.
Thank you, Khushi. Thank you, sir.
Thank you, Kushi. See, the terms and conditions must contain an option for the lender to convert the loan into equity. Okay, it should be there. Then in terms and condition, you have to say that you should give an option to the shareholder. Okay, there should be an clause should be there. It should be converted at the option of the lender. Okay, to convert the loan into equity. And he have to give a letter to the company stating that, sir, I want to convert my loan which I have given to the company into equity. Okay, only after receiving that letter, you have to convert that loan, which what you have received from that lender, to equity. Okay, he must exercise his option. Okay, simply we can't convert the loan into equity. Okay, I have given the money to the company. I have to say that I want that loan into converted to equity. Okay, company on its suo motu, we cannot do that. So it is an only important point you have to notice down. That's it. Anything else?
No, sir.
No, sir. Thank you, sir.
Okay.
Thank you, sir.
Thank you.
Thank you, sir. Thank you, Khushi.
Thank you.
Thank you, sir.